Hello viewers, in this lesson we will learn about public issue and private placement of debentures as securities. Objectives: to learn about the public offer and private placement of debentures as securities. To learn about the debenture trust. Summary: this lesson explains various issues relating to the public offer and private placement of debentures as securities and also about the debenture trust. Viewers, now we will learn about the public offer and private placement of debentures as securities. The loan capital of a company through debentures can be procured by public offer and private placement as provided under Section 23 of the Companies Act 2013. The definition and kinds of debentures are discussed in Lesson 3. Public offer of debentures can be given only by public companies, as private companies cannot go for public offer of loan capital. A public company can issue debentures to public through prospectus by complying with the provisions under sections 23 to 41 of the Companies Act 2013. A public company can also procure loan capital through debentures by way of private placement as provided under section 42 of the Companies Act 2013. A private company can procure loan capital by issuing debentures by private placement as provided under section 42 of the Companies Act 2013. Sections 23 to 42 of the Companies Act 2013 and the relevant rules thereof contain detailed provisions as to the method and procedure to issue the securities, which includes shares and debentures, either through the public issue by public companies or through private placement by both the public and private companies. The details are discussed in Lesson 4. For the issue of debentures, apart from applying those provisions, the provisions under Section 71 and 72 of the Companies Act 2013 must be complied with. Further, the Companies Share Capital and Debentures Rules 2014, SEBI, Debenture Trustees Regulations 1993, and SEBI, Issue and Listing of Debt Securities Regulations 2008, Issue of Foreign Currency Exchangeable Bond Scheme 2008, SEBI, Issue of Capital and Disclosure Requirements Regulations 2009, SEBI, Listing Obligations and Disclosure Requirements Regulations 2015, Table F of Schedule 1 of the Companies Act 2013, and other related rules, regulations, circulars, orders of SEBI and MCA also must be complied with by the companies. Section 71 of the Companies Act 2013 contains the provisions on issue of debentures in detail. They are as follows. A company may issue debentures with an option to convert such debentures into shares, either wholly or partly, at the time of redemption, provided that the issue of debentures with an option to convert such debentures into shares, wholly or partly, shall be approved by a special resolution passed at a general meeting. No company shall issue any debentures carrying any voting rights. Secured debentures may be issued by a company subject to such terms and conditions as may be prescribed. Where debentures are issued by a company under this section, the company shall create a debenture redemption reserve account out of the profits of the company available for payment of dividend, and the amount credited to such account shall not be utilized by the company except for the redemption of debentures. No company shall issue a prospectus or make an offer or invitation to the public or to its members exceeding 500 for the subscription of its debentures, unless the company has, before such issue or offer, appointed one or more debenture trustees, and the conditions governing the appointment of such trustees shall be such as may be prescribed. A debenture trustee shall take steps to protect the interests of the debenture holders and redress their grievances in accordance with such rules as may be prescribed. Any provision contained in a trust deed for securing the issue of debentures or in any contract with the debenture holders secured by a trust deed shall be void insofar as it would have the effect of exempting a trustee thereof from or indemnifying him against any liability for breach of trust where he fails to show the degree of care and due diligence required of him as a trustee, having regard to the provisions of the trust deed, conferring on him any power, authority, or discretion. Provided that the liability of the debenture trustee shall be subject to such exemptions as may be agreed upon by a majority of debenture holders, holding not less than 3/4 in value of the total debentures, at a meeting held for the purpose. A company shall pay interest and redeem the debentures in accordance with the terms and conditions of their issue. Where at any time the debenture trustee comes to a conclusion that the assets of the company are insufficient or likely to become insufficient to discharge the principal amount as and when it becomes due, the debenture trustee may file a petition before the tribunal, and the tribunal may, after hearing the company and any other person interested in the matter, by order impose such restrictions on the incurring of any further liabilities by the company as the tribunal may consider necessary in the interests of the debenture holders. Where a company fails to redeem the debentures on the date of their maturity or fails to pay interest on the debentures when it is due, the tribunal, that is National Company Law Tribunal, may, on the application of any or all of the debenture holders or debenture trustee, and after hearing the parties concerned, direct by order the company to redeem the debentures forthwith on payment of principal and interest due thereon. If any default is made in complying with the order of the tribunal under this section, every officer of the company who is in default shall be punishable with imprisonment for a term which may extend to 3 years, or with fine which shall not be less than 2 lakh rupees, but which may extend to 5 lakh rupees, or with both. A contract with the company to take up and pay for any debentures of the company may be enforced by a decree for specific performance. The central government may prescribe the procedure for securing the issue of debentures, the form of debenture trust deed, the procedure for the debenture holders to inspect the trust deed and to obtain copies thereof, quantum of debenture redemption reserve required to be created, and such other matters. Nomination facility for inheritance. Section 72 of the Companies Act 2013 vests the power of nomination with the holder of securities to inherit the securities in the event of his death. The section contains detailed provisions in this regard. These provisions apply alike to holders of shares, debentures, and other securities. Viewers, now we will learn about the debenture trust. According to subsection 5 to section 71 of the Companies Act 2013, no company shall issue a prospectus or make an offer or invitation to the public or to its members exceeding 500 for the subscription of its debentures, unless the company has, before such issue or offer, appointed one or more debenture trustees, and the conditions governing the appointment of such trustees shall be such as may be prescribed. For complying with this provision, the company must form a debenture trust by executing a debenture trust deed and registering the trust under the Indian Trusts Act 1882. Pursuant to this provision, the central government framed Companies Share Capital and Debentures Rules 2014. The relevant conditions governing the issue of debentures and appointment of debenture trustees are narrated under Rule 18, which are as follows. 1. Under Rule 18(1)(c), the company shall appoint a debenture trustee before the issue of prospectus or letter of offer for subscription of its debentures, and not later than 60 days after the allotment of the debentures. Execute a debenture trust deed to protect the interest of the debenture holders. And under Rule 18(1)(d), the security for the debentures by way of a charge or mortgage shall be created in favor of the debenture trustee on any specific movable property of the company or its holding company or subsidiaries or associate companies or otherwise. Any specific immovable property wherever situated or any interest therein, provided that in case of an NBFC, the charge or mortgage under subclause 1 may be created on any movable property. This subrule does not apply to the debentures secured by the guarantee given by any government issued by the government companies. Further, in case of any loan taken by a subsidiary company from any bank or financial institution, the charge or mortgage may also be created on the properties of the holding company. Under Rule 18(2), the company shall appoint debenture trustees under subsection 5 of section 71 after complying with the following conditions, namely, A. The names of the debenture trustees shall be stated in letter of offer inviting subscription for debentures and also in all the subsequent notices or other communications sent to the debenture holders. Before the appointment of debenture trustee or trustees, a written consent shall be obtained from such debenture trustee or trustees proposed to be appointed, and a statement to that effect shall appear in the letter of offer issued for inviting the subscription of the debentures. A person shall not be appointed as a debenture trustee if he beneficially holds shares in the company, is a promoter, director, or key managerial personnel, or any other officer, or an employee of the company, or its holding subsidiary or associate company. He is beneficially entitled to monies which are to be paid by the company, otherwise than as remuneration payable to the debenture trustee. He is indebted to the company or its subsidiary or its holding or associate company or a subsidiary of such holding company. Has furnished any guarantee in respect of the principal debts secured by the debentures or interest thereon. has any pecuniary relationship with the company amounting to 2% or more of its gross turnover or total income or 50 lakh rupees or such higher amount as may be prescribed, whichever is lower, during the 2 immediately preceding financial years or during the current financial year, is relative of any promoter or any person who is in the employment of the company as a director or key managerial personnel. D. The board may fill any casual vacancy in the office of the trustee, but while any such vacancy continues, the remaining trustee or trustees, if any, may act, provided that where such vacancy is caused by the resignation of the debenture trustee, the vacancy shall only be filled with the written consent of the majority of the debenture holders. Any debenture trustee may be removed from office before the expiry of his term only if it is approved by the holders of not less than 3/4 in value of the debentures outstanding at their meeting. Rule 3 narrates the duties of the trustees, which are as follows. It shall be the duty of every debenture trustee to satisfy himself that the letter of offer does not contain any matter which is inconsistent with the terms of the issue of debentures or with the trust deed. Satisfy himself that the covenants in the trust deed are not prejudicial to the interest of the debenture holders. Call for periodical status or performance reports from the company. Communicate promptly to the debenture holders defaults, if any, with regard to payment of interest or redemption of debentures and action taken by the trustee therefor. Appoint a nominee director on the board of the company in the event of 2 consecutive defaults in payment of interest to the debenture holders or default in creation of security for debentures or default in redemption of debentures. Ensure that the company does not commit any breach of the terms of issue of debentures or covenants of the trust deed and take such reasonable steps as may be necessary to remedy any such breach. Inform the debenture holders immediately of any breach of the terms of issue of debentures or covenants of the trust deed. Ensure the implementation of the conditions regarding creation of security for the debentures, if any, and debenture redemption reserve. Ensure that the assets of the company issuing debentures and of the guarantors, if any, are sufficient to discharge the interest and principal amount at all times, and that such assets are free from any other encumbrances except those which are specifically agreed to by the debenture holders. J. Do such acts as are necessary in the event the security becomes enforceable. Call for reports on the utilization of funds raised by the issue of debentures. Take steps to convene a meeting of the holders of debentures as and when such meeting is required to be held. Ensure that the debentures have been converted or redeemed in accordance with the terms of the issue of debentures. Perform such acts as are necessary for the protection of the interest of the debenture holder and do all other acts as are necessary in order to resolve the grievances of the debenture holders. Rule 18(4) states that the meeting of all the debenture holders shall be convened by the debenture trustee on A. Requisition in writing signed by debenture holders holding at least 1/10 in value of the debentures for the time being outstanding. B. The happening of any event which constitutes a breach, default, or which in the opinion of the debenture trustees affects the interest of the debenture holders. Rule 18.5 states that for the purposes of subsection 13 of section 71 and subrule 1, a trust deed in form number SH12 or as near thereto as possible shall be executed by the company issuing debentures in favor of the debenture trustees within 3 months of closure of the issue or offer. Under Rule 18.6, the provisions of subrules 2 to 5 of Rule 18 shall not be applicable to the public offer of debentures. Under Rule 18.7, the company shall create a debenture redemption reserve for the purpose of redemption of debentures in accordance with the conditions given thereon. Under Rule 8a, a trust deed for securing any issue of debenture shall be open for inspection to any member or debenture holder of the company in the same manner, to the same extent, and on the payment of the same fees as if it were the register of members of the company. And B, a copy of this trust deed shall be forwarded to any member or debenture holder of the company at his request within 7 days of the making thereof on payment of fees. Under Rules 18, 9, 10 and 11, the exemption clauses are narrated. Here, certain class of companies are exempted from compliance with the rules. The exemption clause under subsection 7 to section 71 referred afore is different from this rule as it relates to prohibiting any clause to be made in the trust deed so as to exempt any trustee from liability in case of his dereliction of duty, careless and negligent conduct. Well, viewers, I hope you have enjoyed this lesson. We will meet again. Thank you.